Good morning, Mr. Costello. Let me explain, although you may have observed, you will see the lights. When the yellow light is on, it's time to wrap up, and when the red light goes on...
Kill it.
Thank you, and you have 10 minutes. Good morning, Mr. Costello.
May it please the Court, I am Tom Costello, the petitioner or plaintiff in a proposed civil action for contempt in the land court. A verified complaint was filed or attempted to be filed in the land court, and it was refused to be docketed. Under Rule 65.3, you don't do what is ordinarily done, is pay them $1 or $5 for a summons. You must go ex parte to the judge to obtain a summons, and on that summons he has to hold a hearing of some sort in 10 days. And that was also refused. I requested that I argue before the judge, and that was denied by the clerk. All of that, I believe, constitutes a denial of a constitutional right of due process of law. Now, if this were a probate or superior court matter, your prior cases dictate that one must go to the administrative offices over here in Center Plaza and get them to get the clerks and the judges to go on the straight and narrow. But the land court doesn't have an administrative office. There is no way to go to that level under those prior cases. The other thing that could be argued is that I should have taken an appeal to the appeals court. In order to take an appeal to the appeals court, you have to follow the form that's in the Rules of Civil Procedure, which state, in the above entitled action, I hereby appeal. Well, there is no above entitled action. They wouldn't docket it. From the judgment or order, there is no judgment or order. They wouldn't issue one. Entered on a certain date. Nothing was entered. There is no contempt docket. There is nothing entered. I would also ask you to take notice of the supplemental citations that I filed and the fact that in the action before the single justice, certified by the town clerk copies of the Lexington rules are in your possession. And also take note of the Oakham Sand and Gravel versus the town of Oakham case, which says even though there may be an underlying action, a person is entitled to proceed with a contempt action if there is contempt. The underlying action is an allegation of seven acts of published contempt of 4 final judgments. All of the elements for contempt were met in the verified complaint. The defendants have notice of the judgments. The judgments are clear. They're able to comply, and they refuse on demand to comply with those judgments. It really all comes down to the Berg case, which is cited in my brief, that if one is willing to construct a way to town standards, then one is entitled to a building permit even if the way is not yet built. Those are the exact words out of that case. I am willing to construct the road under the Chapter 41, Section 81Q standards, commonly applied standards. And if there's any doubt about it, whatever that higher standard is, I will do. Every lot abutting this lot in Lexington, first off, it's registered land. It exceeds the zoning minima for frontage and area. Every lot abutting this lot has a single-family dwelling on it, including those lots across the street. The town has installed sewer and water in this way and assessed betterments to this lot. This lot is also assessed as a building lot. I think that each member of this court has taken an oath to support and defend the due process clause of the Constitution, and that is a person should have a right to file a complaint in the court and have his day in court and be heard. That right was denied here, and I'm asking you to honor your oath and remand this back to the land court with an order that a complaint cannot be refused unless it's by an order of a judge. not be refused to be docketed. If nothing is done here, then you will have emboldened these people in the town to get even worse. When I was elected to the Lexington Planning Board quite a few years ago, there was a time when the town lawyer came to the meeting, and one of the members of the board said to the attorney, "How far can we go, what we do here?" And it's indicative of what goes on in a lot of towns. Town attorneys pander to the boards. And the lawyer said, "You can do just about anything you want to do." So the man on our board said, "Well, why is that?" "Well, it'll take them 7 years to go through the process, cost them about $40,000 to do it, and then you're not going to find people to do it. They either haven't got the backbone to do it, or they don't have the will or the time to do it. So I shouldn't be litigating these issues that happened in Berg, or the Cassani case that they violate, or the West Bridge, the Cumberland Farm case where they refused to endorse perimeter plans. It's not just a refusal to endorse perimeter plans. It doesn't allow people to get a 3-year zoning freeze. And so what I'm saying is I'd like to have my day in court before the land court on these issues. Thank you.
Thank you, Mr. Costello. Mr. Butt?
Thank you, Your Honor. Kevin Bott, representing the town of Lexington, various officials that are the defendants and appellees in this case. Your Honor, this case doesn't warrant your exercise of your extraordinary superintendent's powers because, first, there is no substantial claim of a violation of a substantive right.
Go ahead.
On that basis, there was a completely insufficient complaint for contempt that was presented to the land court.
Let me ask you this. Is the plaintiff correct that the complaint was not docketed and the clerk refused to issue a summons?
Your Honor, it is reliant on his experience and his affidavit to that effect in his verified complaint.
It seems to me that one of the problems here is that there's been a determination that the complaint lacked merit, right? But the problem that I have is, as a general matter, and it may be onerous and it may be burdensome, but a complaint is filed and docketed, a summons issue, and the defendants file a motion to dismiss, maybe with fees, requests for fees. If I simply accept that somebody went to file a complaint, but the clerk refused to docket it and refused to issue a summons, don't I have a bit of a problem?
Well, Your Honor, my understanding from what Mr. Costello has presented happened to him, the clerk did go to Judge Twombly, who then refused to issue the summons. This court last spring in the rescript opinion, Parker versus the Commonwealth, has a note that if a complaint is insufficient on its face, then there is no requirement that either a summons issue or a hearing be held. Now, how the land court implemented that kind of procedure is something that's not in the record.
But don't they at least have to docket the complaint?
Have you checked to see whether it was docketed?
I've relied on what Mr. Costello has represented.
The complaint itself
docketed.
doesn't seem to refer to any judgment or anything, so it probably could be dismissed with a quick motion to dismiss, but at least it has to be docketed, doesn't it?
Well, my understanding, Your Honor, from what happened in the land court, which is granted in the record obscure, but that the complaint was not deemed sufficient in order to hold a hearing or issue a summons.
Well, then why do we have Rule 12b-6?
Well, in a contempt situation under Rule 65.3, the defendant is not notified that the complaint has been filed against them. It's, as Mr. Costello says, an ex parte proceeding in which the plaintiff comes to the court to see if there is sufficiency for a summons to issue. So, of course, we as the defendants in the town of Lexington were not given a summons in that case. We had no notice that there was even a complaint filed. We had no notice, in fact, until Mr. Costello had already gone to the single justice, who had denied also the issuance of a summons.
I understand 65.3, and I understand that the summons shall issue only on a judge's order and shall direct the parties to appear at the court, so on and so forth. And you've got to satisfy the judge because there's the contents of the complaint. What concerns me a little, and I can't tell from here, in part because I don't have a copy of the land court docket, and maybe there isn't a land court docket, is how we, if, for example, can there ever be a challenge to the failure to issue a summons?
Well, what I did find out with the land court docket, Your Honor, is this was the number that Mr. Costello filed this under was a land court proceeding back in 1991. It took me some time to get a copy of that file because it was so old that it could be that the land court on the face of the complaint was not able to retrieve that docket and even make an entry.
You're saying that so that rather than as it were commencing a new action with a complaint for civil contempt, this was filed?
This is a complaint. The docket number refers to the land court registration, which Mr. Costello has also included in your record appendix,
Sure.
which was a 1991 land court decree.
Could he have gone to the appeals court?
Well, I see no reason why.
If so, is the single justice correct on that point alone? Alternative remedy?
How can you go to the appeals court if you don't, I mean, from what is he appealing? The failure for the land court judge to issue a summons, or from the failure of the clerk to docket the complaint?
Both.
Well, I think there are a number of things, and it's sort of difficult in the papers to quite understand, including an oral argument. His remedy as to what he alleges is the actions in violation of some kind of command. His remedy there is the pending land court case, which he says.
No, I don't think that's the case. Right? I mean, I think if you certainly you have to show that there is a clear order and so on, but you have a parallel proceeding, don't you? You don't have it with. You can have it within that case, but you don't have to.
The underlying actions of contempt are several, but the one that's germane to what Mr. Costello has just argued about the parcel in Lexington, he appealed the failure of the
I understand
zoning
that
board.
his grievance today is that the land court clerk refused to accept the complaint for filing. Now, can't that be taken care of in the appeals court? He doesn't belong here.
I think that can be taken care of in the appeals court, Your Honor. I think there's concurrent jurisdiction.
Land court exempt from going up under 231-118?
Absolutely not.
Well, then,
do complaints for contempt get a new docket number or
Yes.
the same docket?
Well, it depends how you're proceeding. If you're proceeding for civil contempt, it says our rule 65.3 says a separate civil proceeding denominated as a civil contempt proceeding. Maybe that was the problem here.
I understand that normal practice, Your Honor, is to file on the docket where the underlying judgment or order has been issued.
but Mr. Blatt, if we allow him to file the complaint, then the land court can say, I think legitimately, we're not issuing any summons on this because you don't identify any judgment in which any of these people could be held in contempt. And then on this 211.3 thing, we could say he should have gone to the appeals court, dismissed up here.
Your Honor, I think that whether or not the complaint for contempt is docketed in the land court, if you were to remand this case back,
We don't even have to get that far. If he should have gone to the appeals court in the first place, we can just say 211.3 doesn't permit him to come here.
I agree with Your Honor that 211.3 is not the right proceeding to bring before this court this particular complaint.
Thank you, Mr. Butt.